In this video, we will continue our examination of the seller's remedies in the event of the buyer's breach by focusing in on the scenario where the buyer breaches the party's contract before the goods have been delivered to the buyer, where the goods are still in the seller's possession. First, it might be helpful to imagine the circumstances that might result in this kind of situation, where the seller has the goods and the buyer is in breach of its obligation to pay the seller. It is more common than you might expect. There are a number of reasons where the seller still has the goods when the buyer breaches. For example, perhaps the buyer wrongfully rejected the seller's conforming tender and therefore refused to pay the seller, and upon the buyer's wrongful rejection, the seller has taken back the goods that the buyer rejected. Or perhaps the party's contract required the buyer to prepay for the goods, to pay the seller in advance before the goods would be tendered or delivered to the buyer, and the buyer failed to pay in advance as she was contractually required to. Or perhaps, before either party performed under the contract, the buyer repudiated its contractual obligation to pay or accept conforming goods from the seller before any goods were actually delivered. Regardless of the nature of the buyer's breach, where the goods have not yet been delivered to the buyer, the seller may assert a number of legal remedies. Those legal remedies are listed under Section 703 of Article 2. Those remedies include the right of the seller to withhold or stop delivery of the goods, the right of the seller to then cancel the breached contract with the buyer, and finally, the right of the seller to seek monetary damages against the breaching buyer, with the measure of the monetary damages depending on the facts and circumstances of the specific case. And that list provides a roadmap for our discussion. In this video, we will consider the first of these two remedies, saving the rest for the next two videos. So let's start first with the seller's right to withhold or stop delivery, both of which are remedies identified in Section 703 of Article 2. So what is the difference between withholding and stopping delivery? The difference is simple. If the seller still has possession of the goods, then the seller can withhold delivery of the goods. But if the seller has already given the goods to a third-party carrier to deliver to the buyer who has since breached, the seller must stop delivery of the goods. Both options are generally permitted under two circumstances. First, under Section 702 subsection 1, if the seller discovers the buyer to be insolvent prior to delivery of the goods, then the seller may elect to either withhold or stop delivery of the goods. The second circumstance is one that's addressed in Section 703 of Article 2, where the buyer is in breach of the party's contract at any point prior to delivery of the goods. Under either of these scenarios, where the seller has the right to withhold or stop delivery of the goods, there is a distinction between withholding and stopping that bears at least mentioning. Unlike the seller's right to withhold, the seller's right to stop delivery is further limited by Section 705 subsections 2 and 3 of Article 2. The rationale for the limitations set forth in these subsections is that the seller's stopping delivery is different than the seller's withholding delivery. In the case of withholding, the seller has possession of the goods, and so the seller's decision to withhold does not affect anyone other than the seller and the breaching buyer. In contrast, in the case of stopping delivery, by definition, some third-party carrier has the goods. So the limitations on the seller's right to stop delivery set forth in Section 705 are aimed at protecting the neutral third-party carrier that finds itself caught up in a dispute between the seller and the breaching buyer. Aside from merely noting these limitations, we will not further consider the seller's right to stop delivery, because as we have noted before, for the purposes of our course, we are making the simplifying assumption that the party's contract contemplates a direct tender of goods from the seller to the buyer, without the use of an intermediary third-party carrier. In addition to withholding or stopping delivery, after the buyer breaches, under Section 703 subsection F, the seller may also cancel the contract. Like cancellation by the buyer in the case of the seller's breach, the seller may cancel the contract upon the buyer's breach. And like the buyer in the event of the seller's breach, the seller may cancel without giving the breaching buyer notice of its cancellation, although in practice, such notice is always advisable. One important point to keep in mind about the right to cancel is that the right to cancel is limited in the context of installment contracts. As we have previously noted, pursuant to Section 612 subsection 3, neither the buyer nor the seller may cancel an installment contract unless the other party's breach substantially impairs the value of the contract as a whole. So how does this rule play out in the specific context that we're interested in, where the buyer is in breach? Well, imagine a scenario where the parties' contract contemplates that the seller will deliver goods to the buyer on a weekly basis for a 1-year period and that the buyer will pay for those goods upon delivery. But after a few weekly deliveries and payments, the buyer then fails to pay for the last weekly installment. The buyer's failure to pay for that last installment might understandably give the seller reason to believe the buyer is unable and unwilling to pay for all future installments. And of course, if the buyer is in fact unable or unwilling to make any further payments under the contract, that would substantially impair the value of the contract for the seller. After all, in that scenario, the seller is facing the prospect of delivering goods on a weekly basis and getting paid nothing. But perhaps the buyer's failure to pay for the last installment might be simply due to the fact that the buyer is undergoing a temporary cash flow problem. Stated differently, perhaps the buyer is perfectly solvent and able to pay for future weekly installments, it's just late in paying for the last installment. In that scenario, though the buyer might be in breach, there probably has been no substantial impairment. The seller will still continue to get paid, it's just that one weekly payment was not made on time. Assuming there was no substantial impairment, any attempt by the seller to cancel the contract and refuse to make further deliveries where the seller has no right to do so would put the seller in breach for repudiating the contract. This again highlights a point we made when we discussed installment contracts previously, which is that whether a breach constitutes a substantial impairment of an installment contract as a whole is a highly fact-specific question. In practice, this means that, like a buyer, a seller must be very cautious in canceling an installment contract on the basis of substantial impairment, because it is difficult to predict ex ante how a court might resolve the question of substantial impairment if the buyer challenges the seller's actions in canceling their deal. Therefore, like a buyer in an installment contract, the seller might be better off requesting adequate assurances from the breaching buyer rather than attempting to exercise its limited right to cancel. Assuming the seller does have the right to cancel, the effect of the seller's cancellation is the same as when the buyer cancels. The seller is excused from further performance. Stated differently, the seller has no further obligation to deliver goods to the breaching buyer. Moreover, upon the seller's cancellation, the seller retains the right to damages against the buyer for the buyer's breach. From a practical perspective, the seller might reasonably choose to stop at cancellation, to avoid the cost and expenses that the seller will incur in seeking any additional legal remedies for the buyer's breach, expenses such as attorney's fees and the wasted time of the seller's employees working with the attorneys. A seller might rationally decide to simply move on, to try to sell to someone else the goods that the breaching buyer was supposed to pay for, and then resolve itself not to contract again with this breaching buyer. The seller's decision to stop or withhold delivery of the goods and then cancel the contract and do no more would especially make sense where damages that the seller might hope to recover from the breaching buyer are relatively small as compared to the costs the seller would incur in pursuing its other legal remedies. But if damages against the buyer is what the seller wants, then in the next two videos we will see the measure of the seller's damages in this context. The measure of the seller's damages where the seller is in possession of the goods and the buyer is in breach.